To be with you now is
Okay.
this I'll call this a wonderful moment. I, as a matter of fact, um, want to say that this is a live video. It's a chat. It's a discussion concerning what I believe will be of interest, to us. Share our ideas. We have so many things bedeviling our country now. I don't want to talk about what is happening in America. I don't want to talk about what is happening in the UK. I don't want to talk about what is happening in China. My focus is on my country. There are a lot of things, bedeviling our nation. But do we have to kill ourselves to solve all these problems? Not at all. Uh, but there is one which I'm very much more concerned about is the the strike, the JUSUN strike that uh, we are faced with now as a major challenge, which has kept um, a lot of lawyers almost idle, especially lawyers in active litigation practice, because the strike, as a matter of fact, did not affect um, the entire legal profession by the nature of law practice in our situation. There are so many other non-litigation based services that we have today, which a lot of lawyers, some lawyers have actually found their niche in such areas and are doing so well there. But litigation is about the first thing to be considered when you are talking about law practice. So you talk about litigation first before every other area. Law practice is versatile. There are a lot of other areas that are connected with law practice as it were. But litigation is one unique area which makes the legal profession unique and complete. But without litigation, it could well be said that there is no law practice. That's how some people think. Uh, but for me, I believe a lawyer should be a dispute resolution practitioner. So when you have that mindset as a lawyer, that you are a dispute resolution practitioner, um, whether there is strike or not, whether the courts are open or not, you will definitely be very much active in practice. So there is nothing like, okay, because the courts are shut down, you are no longer in active practice. I am not of that school of thought. There are some lawyers who think that uh, if the courts are shut down, it's as good as saying that uh, lawyers are no longer in active legal practice. Now, there are a lot of other areas you can be in active legal practice apart from litigation. But I must, note here that this strike is more like an eye opener. It is more like a way of teaching us a lesson. making us to know the need for us to consider alternative uh, dispute resolution practice or um, cross-disciplinary dispute resolution practice. When I say cross-disciplinary dispute resolution practice, what I mean is that lawyers had better start considering or thinking about how to look at other areas of law practice, which are basically dispute resolution, but don't really have anything to do with litigation as well. And even if they do have something to do with litigation, it's expected that with creativity, a lawyer can think about how to um, re-strategize and make something that ordinarily should be litigation based, non-litigation based. In other words, if you are supposed to do something that will result to litigation, if your client is supposed to get involved in something that will result to litigation, you've got to do something about advising that client to think about um, a non-litigation dispute resolution strategy as a way of solving that problem for the client. And that is also one way you can help the client to cut costs. One thing that lawyers have got to know now is that most clients are becoming burdened by the cost of litigation. So they look for cheaper ways they can solve their problems. Not every lawyer really, not every client really likes to go to court. So sometimes some lawyers, um, some clients tend to act on the advice of lawyers to go to court when ordinarily such matters can be resolved by uh, some hybrid dispute resolution mechanisms like mediation, conciliation, negotiation, regardless of the nature of the matter. Even in criminal matters, you do what we call criminal mediation in criminal matters. I always say that, emphasize it on several occasions. I've talked about it on several occasions, but a lot of people still are yet to buy that particular idea. But I think with this JUSUN strike, the orientation of lawyers about litigation practice has got to change now. So after the strike, it is expected that lawyers should begin to think about how to re-strategize about their practice, how to go about their practice. Uh, you have to do a profiling of the cases you have. There are some cases that you have got to think about um, using modern strategies of lawyering to help your client to resolve the problems that are bound in such cases without the need of making sure that the matter goes to the finality, gets to the finality that you so desire, which sometimes may not actually be the desire of the client. Our focus in law practice now should be client-centered practice, not the traditional model, which some scholars have actually described as the the zealous advocacy model. Now we now have a new model of law practice, not neutral partisanship. Rather, this one is client centered. In this client centered approach, it is good that you begin to think about what is good for your client. What are those things that those remedies that you think would be of great benefits for your clients without the need for you to resort to litigation as a way of solving the problem. So sometimes you look at the cost of the litigation as it were. You look at the inconvenience some psychological factors. You consider them. You look at um, some other factors like relationship, your reputation. These are some factors that are considered before you begin to consider litigation. Not that the moment a client briefs you, all you think about is litigation. You've got to, I think lawyers had better start de-emphasizing litigation. I know very well that there are some areas where you cannot really do without litigation. And in such areas, the law has got to speak, especially when the matters involved are constitutional matters. But other than constitutional matters or serious, criminal matters, commercial matters, matters relating to business transactions, even family issues and what have you, need not be taken to the court. And that does not mean that you, as a lawyer, won't be paid your lawfully uh, entitled benefits. You've got to be paid because you have rendered services. So it is good that lawyers begin to package their services, look at the kind of services that you render. You've got to have a brand as a lawyer. Your law firm should be a brand. The letterhead of your law firm has got to be a brand. Right in the letterhead of your law firm, you've got to have what I call reputation. That when the letterhead of once your letterhead your letter goes out, it doesn't go out just for the sake of it. If it goes out, it must come back with something. That is one unique thing about practice. We should think now about how to re-strategize um, our practice. We need to think about how to go a new way we can, practice law. We don't have to forget the fact that before now there was the COVID-19 pandemic, which affected litigation as it were, and now you have the JUSUN strike, which has actually kept lawyers at home for almost a month now, and to a great extent, it appears nothing has been even said about when the strike will be called off. So the question is, what is the way forward? I don't even want to talk about how the strike affects access to justice. And that is one area that I feel pained about the kind of justice administration system that we are faced with in Nigeria. And it is high time our governments, it is high time all stakeholders in the justice administration system uh, thought about how to make the judiciary truly independent. We can adopt the American administration office model. You can do your research about that. It's there. I think it was developed in 1939 or thereabout, and since 1939 to date, it has been there. You can't do anything to obstruct justice in any way. Imagine people who are in our various correctional centers across the country. Some are supposed to have gained of their freedom by now, but for no fault of theirs, they are there. and some persons are telling us that's the price we are going to pay. Yet some people are receiving salary. It doesn't make any sense. For those people who are yet to think about this, they have got to start considering that fact that it doesn't make any sense. The JUSUN members have got to be paid their salary, and you are telling me they are fighting for judicial autonomy. The other stakeholders in the system, they know themselves. They have got to be paid their salary. Some people have got to receive some benefits. If you are telling me that some people are not going to receive any benefits, no benefit is going to be received by anybody, then I understand. The only people I can say are not going to receive any benefit as such are those lawyers who are seriously into private litigation practice, into private practice, who are actually active in our various courts as far as litigation is concerned. These are the people who are more or less not going to have any bites in terms of benefits as far as this strike is concerned. Because it's only when the court is open that you go back to they'll go back to the court to apply their trade. The court is their farm. But apart from these people, the members, the JUSUN members, these people, they are where? They are in the judiciary. They are entitled to their monthly salary, which no law can take away from them. So you cannot even say because they embarked on a strike and as such they are not going to have any benefit. Okay, let us equate the monthly salary of JUSUN members, or let us equate the monthly salary, the salary of some other stakeholders in the justice administration system with the life of someone in our cell, in our correctional centers or in police cell. Can we equate it? Is it possible? We cannot. That is the more reason we have got to think about the need to call off the strike. I'm using this opportunity to say it. I don't need to be afraid of anybody. I'm a lawyer. Nobody paid my school fees. I trained myself at the university. At the law school, I paid my school fees. So I've got to start. I can say here that what I'm saying represents what is on my mind. A strike that affects, that has closed down our courts is an unjust strike as far as justice is concerned. It reminds me of when I was doing my postgraduate program in one of the universities in Nigeria. I was in the heat of my final examination when ASU went on strike. In fact, the way I felt that day, the pain, the inconvenience, traveling from one state to the other state, having written one paper, coming out of the classroom, getting to understand that we cannot continue the exam because of ASU or ASU strike, as it is called. It is very shameful. But I'm happy today that the strike, the ASU strike, has actually changed my orientation about learning in a new way. That I don't need to depend on some persons in order to know what I am supposed to know. I've got to go out there, use all means possible, provided they are lawful, to acquire any knowledge that I really want to acquire. I'm saying this today because I'm pained about this situation. I'm not happy about it. The strike is not something. This JUSUN strike is not something that should be ahead of. Now, let me tell you what happened today. As I was coming to the office, I'm speaking from my office. As I was coming to the office, a policeman stopped the tricycle that I boarded. There was a girl in the tricycle. She was told to come down. They checked her and all that. Because of the way I have decided to dress, I washed my car everything this morning. I steamed it. I enjoyed myself right inside. I went to buy fuel. Then when I came back, I packed it there because I've actually taken it upon myself to live a simple life. Having a car is not an enjoyment, and then it's not evidence of enjoyment. It's a necessity. So you only drive when it is necessary. So I didn't see the need for me to drive as I was coming to the office. I decided to board the tricycle. Some policemen stopped us. They stopped the girl. The girl came down. They checked, lighted. They checked her, and they observed that she was she didn't have anything. Then they were looking at me, and I introduced myself. Even having introduced myself as a lawyer, one of them told me uh, to calm down. So I alighted. When I alighted, they asked me what I had in my bag. I said there was not enough in my bag, but I introduced myself. They said they were doing stop and search. Stop and search. It's okay, there's no problem. I said, okay, you can check my bag and all. But I said I was not aware that there was anything like stop and search. If there was anything like that, of course, if there's any security breach, you should have let us know so that we'll know. Then people have got to be careful about how they move. Right in that bag, there was my laptop. There were so many other things. But I knew what they were after. And after everything, I told them, okay, there's no problem. I'll give you a call. I know the persons that I'm going to call. And by the time I call these persons, I'll be able to get an idea as to what the security breach is all about. So they thought I was joking. I got to the office, I dropped my bag, and I went back to that particular place where the policemen were. I wanted to have the um, the particulars of the police officer in charge of that particular thing. In less than 5 minutes, I got to that place. I didn't see them again. Maybe because they got to know that I wanted to do something. Now, assuming without conceding, assuming that I was this kind of radical, or assuming I were, let me use were, the subjunctive, as the case would be. Assuming I were this kind of person who wanted to prove to them that there was the policeman, there was no way a policeman could check me to conduct a search on me, since there was no information about that. Even if I was right in law, then something ensued, and what of the violence here, and before you know it, something terrible happened. What would they be saying? That is just a fallout. Now, let me ask you this question: do you know why those men in uniform were there? Those men in uniform were right in that particular place because they knew that if anybody is arrested at that particular point, the stop and search point, when there was no security breach anywhere, the, if anything happens to anybody there, what is going to happen? The person will be taken to where? To the police station, and when the person gets to the police station, the person is going to bail himself and they will collect some huge amount of money, from the person, as case may be, if the person doesn't know his left from his right. But because I'm a lawyer, of course, you know very well that you can't even do that to me. I have decided by the grace of God, with the help of the Holy Spirit, to be a law abiding person. So I will have to act in line with the law. But I want to tell you here that they were there because they knew that there is nothing anybody can do again. At no matter how it is, if you are arrested, you'll be taken to where? You'll be taken down to the police station. And you could just be there and they can demand any amount of money they want to demand from you. Why? Because our courts are short. So it's like freedom for some of the unlawful law enforcement agencies to do whatever they like. So I am advocating. I am not appealing to JUSUN to call off the strike. What I'm saying is that as a matter of law, the strike should have been called off by now. Go and look at your laws. Go and look at your laws. Wear your thinking cap and tell me that you have the right to shut down the courts in line with the laws. Is there anywhere you have in our constitution that says that you have the right to shut down the courts? Is there no lawful ways you can implement judgment of courts? Is embarking on strike the only option that you have? Have you heard anywhere in the world that the courts are shut down? If this government decide to suspend the constitution now, and they decide to shut down the courts, will you like it? Or let me use it in this expression: would you like it? So if you wouldn't like it, why are you doing it? Why are you doing it? Everybody's quiet. Some people are talking about solidarity. What kind of solidarity are you talking about? We need to call a spade a spade. It is wrong, it is wrong. What is wrong is wrong. The only time I actually supported anything concerning judicial autonomy was in respect of the position of the NBA on it. And I stand with that particular position. I support judicial autonomy 100%. But the question is, who are the people that have the rights by nature of their practice to fight for judicial autonomy? The people that truly have the power to fight for judicial autonomy are even the lawyers. And I know if the lawyers are to embark on a project like this, they will not go on strike because they know the implication of so doing. They wouldn't go on strike. They wouldn't obstruct the cause of justice. They wouldn't do anything like that. They will have to think about a lawful way they will go about it. For those of you who think that some persons may have paid me, please mind you, nobody can pay me. You can't even buy me. I am sold out to use my practice to promote the work of God. I'm sold out to use my practice to preach the word of God. And if nobody wants to tell you the truth, those people who are on strike, I am saying it here that you people are wrong as far as this strike is concerned. You need to put on your thinking cap. On my own, I I'm even advocating now that there should be a constitutional amendment concerning our laws as they relate to judicial autonomy. There should be a different body, an independent body, that will take care of the finance, that will take care of the fund of the judiciary. Not even the judges, because you will expose them. The business of the judge is not the business of managing finance. What is the business of the court, of the judge? With management of a court finance. The business of the judge should be that of what? Justice administration. There should be an independent body that we should set up to manage the finance of the court. That independent body should be a body responsible to the State Judicial Service Commission, as the case may be, the NJC, as the case may be, and they will submit their budgets to the relevant lawmaking houses. At the federal level, we're talking about the National Assembly. For the National Assembly to consider their budgetary allocation, expenditure, and what have you. Then they know what to do as far as the funding is concerned. The governors will have no business as far as the funding is concerned. The president should have no business as far as the funding is concerned. So there is an independent body. That independent body will be headed by a director. It is that director that will be managing the fund for and on behalf of the judiciary. But the director will be responsible to who? To the judges. That is the American model. And I think we had better consider that particular model. You cannot shut down the courts all in the name of fighting for what? Judicial autonomy. You are fighting for judicial autonomy and you are obstructing access to justice. What kind of fight is that? I'm only appealing to the NBA. I want to appeal to the NBA. I'm not appealing to JUSUN. I'm appealing to the NBA to invite JUSUN, the national officers of JUSUN. NBA should invite them for a meeting and tell them the true position of the law. Sentiment and the law are two different things. You don't whip up sentiment all in the name of fighting for justice. No, you don't do that. Follow the law to fight for justice. I'm also proposing here that there should be a paralegal, a private paralegal staff department, different from the conventional public servants that we have in the state judiciary or at the federal level. So the private paralegal staff members are officers of courts that can do the same job that the conventional officers of court are doing. So they supplement the effort of the conventional officers of court. So if the conventional officers of court, the public servants, the civil servants, they have the view that their welfare is not well taken care of, they can go on strike, no problem. But it cannot stop the court from running. It cannot stop the court from running. So that is why that this is actually where the private paralegal staff model is necessary. So that particular model will help the court to keep running. It's just that when the public servants resume, the work will now become more efficient and faster, as the case may be. But not the situation where you relax everything, you leave everything for who? For public servants. It does not work like that. There are private paralegals, there are firms that consult for law courts abroad. There are law firms that consult. They have paralegal departments that consult for courts. They send paralegals, consultants. You have some of them. They are court reporters. Some they are clerks and all that. They are there in our courts, working in our courts. In the courts abroad. I don't mean the court here. So I think we should consider that. You can imagine a system, a society where the courts are shut down and we think it's normal. Is it normal? Please, I'm appealing to NBA, using this medium to appeal to NBA, to call the officers of JUSUN to order, to tell them that they've got to resume, that what they are doing is unlawful. If nobody is telling them, nobody has told them, I will tell them. I don't care what anybody tells me. This is not the first. In fact, you can even insult me. There's no problem about it. Because I know that if I am prepared to even receive more insult, provided it borders on justice. I don't play with justice. I don't play with fairness. Why should we be putting justice, fairness on the table to eat the way we like? If it is safe for me to use it in this way, figuratively, we just want to eat justice the way we like. We want to slaughter justice. We want to destroy justice. We want to finish fairness. And yet we have a lot of people. There are some clients who want to sue, who have been victimized. They want to sue as we speak. They are suffering. There are a lot of prisoners. There are a lot of inmates in our cells today, in our correctional centers, and nothing is being done about them. I can bet you, if there is anything like election petition, few judicial staff members, as the case may be, will be selected to handle such. And the judges will sit. After all, the judges don't go on strike. When you say the court, the judges are not on strike. So, and if the judges are not on strike, but the court workers are on strike, for God's sake, please, I am appealing that the NBA should work out a model so that we can now reach out to the judges. They should think about how to come up with paralegal consultants. Let us work with the judges. The judges are not on strike. If the judges are not on strike, but the court workers are the people on strike, then let us think about how we can get them replaced as they fight for the autonomy they want. To a great extent, I stand for autonomy, but not in this way. I think I will have to stop here. Thank you.